Finally, I'm pleased to introduce our final speaker in this third panel, Mr. Ken Sandy. Mr. Sandy is the founder of Peacemaker Ministries and Relational Wisdom 360. His presentation is entitled Reversing Course on Conciliation Clauses. Mr. Sandy, welcome.
Thank you. Yeah, it's really a privilege to be here. I am learning an awful lot about a topic that is of great interest to me. For the past 30 years, I've encouraged churches, ministries, and Christian-owned businesses to use legally binding conciliation clauses in their contracts, bylaws, employee handbooks, and church membership commitments. And our standard clause commits the parties to 3 levels of resolving a conflict: personal conversations, if that doesn't work, mediation, and if that doesn't work, arbitration. My support for these types of clauses came from my reading of 1 Corinthians 6, 1 through 8, where the Apostle Paul exhorted early Christians to resolve their conflicts, including their legal conflicts, within their churches rather than turning to the civil courts. And these types of conciliation clauses are now in use in thousands of such documents, and they've resulted in countless conflicts being resolved in a conciliatory manner within the community of faith rather than an adversarial manner in civil courts. Now, these clauses have occasionally been challenged in courts, but have almost always been upheld. The primary goal of these clauses is actually to remind people to respond to conflict in a way that's consistent with their religious beliefs, which ideally begins with personal efforts, sitting down one-on-one to resolve the conflicts rather than jumping immediately into mediation or arbitration. And for example, one Christian architect who uses these in all of his contracts told me that since he started using them, he's never even had to call his attorney, because every time he's had a major dispute where he would have called the attorney, started a legal process, he was reminded, hold it, I agreed to resolve this in a biblically faithful way. That means meeting with the other person, getting the log out of my own eye, resolving it. And he said he hadn't had a situation go even to a mediation process since then. So in light of these benefits, I continue to encourage the use of these conflicts or these clauses between parties with equal bargaining power. Now that's important, equal bargaining power, such as 2 commercial business owners who share similar religious beliefs. But in spite of the many positive uses of these clauses, I've recently decided I can no longer recommend that churches and other religious organizations use legally binding conciliation clauses in their membership agreements. The reason for this change is that I've learned of some unscrupulous church leaders using legally enforceable clauses to oppress members who asked unwanted questions or declined to support questionable policies or practices. Religious arbitration clauses can be especially repressive when they're deliberately designed to favor one party over the other, as our 2 previous speakers talked about. Now, we've got lots of safeguards built into our rules of procedure to prevent that kind of bias or imbalance. But even in spite of that, I've grown increasingly concerned about how these clauses can be used by religious leaders in appropriate ways. For example, they could have church members sign these clauses without even realizing what rights they're giving up. And then later on, when a conflict comes up, they feel like they're being dragged into a process against their will. So in light of these concerns, I now recommend that churches and ministries use informal commitments to Christian conciliation in their churches and their bylaws and commitments rather than legally binding clauses. For example, a clause in a membership covenant might say, if I have a conflict with another member or a leader of this church, I commit to making a sincere effort to resolve it according to the peacemaking principles set forth in Scripture. If we're unable to resolve a conflict through personal conversation or informal mediation or through the established disciplinary process of the church, I agree to give prayerful consideration to resolving the matter through a more formal conciliation process as described in these rules. That process is not a legally binding process, but it still reminds parties of the commitment to try to resolve things consistent with their faith. And I think that's more consistent with the biblical principles of loving our neighbors and treating other people as we'd want to be treated. Thank you.